that is a contract at its core. In Maryland, and this is important for leases, but it's important for all contracts. It's important throughout your business, those of you who are going to have contracts. You can contract to do virtually anything in the state of Maryland. As long as you've got two grown-ups who are parties to the contract, they can contract to do anything that they want. There are only two exceptions to that. The first exception is you cannot contract to do something that is against the law, not surprisingly, and you cannot contract to do something that is against public policy, also not surprisingly. I actually got on recently to try to find a good example of something that would be against public policy, and I found one that I liked, which is you cannot contract to break up a family. I thought that was interesting. So you cannot, obviously you can do divorce contracts and things like that, but you cannot contract with somebody else to break up another family. There's a strong public policy in favor of families. We don't want to allow people to contract for something like that. So, so with that in mind, with the idea of what a contract is, and again, a lease is just a contract like any other in Maryland, let's start talking a little bit about some of the common clauses within contracts. So I don't know, can I control the slides? Perfect, thank you. All right, so the first and most common clause within a contract is the term. It is very important. Everybody wants the term. How long is it going to last? It can be very simple. Generally in residential contracts, you'll see something very simple, like contract begins on June 1st, 2018 and ends on May 31st, 2019. In a commercial lease, it's going to be very different. And the reason why is, at least in part, because it's sometimes unclear exactly when the contract is going to start. Generally, for a commercial lease, there's going to be build out. You're going to have to invest. Somebody is going to have to invest in the property. Frequently, that is actually the landlord. So the landlord is going to want to have a term that starts after the work is done. Otherwise, if the term starts on a certain date, let's say the term starts on June 1st of 2018, like we have in this example, and they're not ready till July 1st of 2018, they've started this lease in violation. They've already breached the lease before we even begin. And so what they'll do is they'll put something in there that says, hey, when the work is basically done, that's when it starts. And we're going to let you know, and they're going to want everything to be in writing. So we're going to give you notice 10 days before the work is done, and then you're going to move in. But that's where these things can get a little bit more complicated than a residential lease. Obviously, like I said, both parties want this to be for a term. And from the tenant's perspective, you don't want to spend all that time investing, moving in, and then finding out that 2 months later the landlord gets a better deal and kicks you out. And from the landlord's perspective, they don't want to invest a whole lot of money doing build outs, renovating, all these other things, and have you say 2 months later, hey, I'm done, I'm moving out. So generally, like I said, you're going to want a lease that's several years. The landlord is going to want a lease that's several years. A lease that is for a specific period of time, so you know, is called a term lease. The alternative is a month-to-month. Like I said, you're not likely to find a lease anywhere. You're not likely to find a landlord anywhere that is willing to offer a lease that is not for a specific term. But if you do, be very cautious about taking it, because you're likely to, you may wind up in trouble if the landlord finds a better deal. All right, I'm trying to figure out how to go from slide to slide. Can we go to the next slide? Okay, the next, obviously, probably the most important thing from the landlord's perspective is the rent. In a residential lease, which many of you have probably seen, it is very simple. You know, I'm going to pay, usually what they do is they say, I'm going to pay $12,000 over the course of the year. It's going to become due, 1/12 will become due every month until the year is up. And that's how they handle it. In a commercial lease, it is significantly more complicated, And it is someplace where you really need to do the reading. And we're going to talk later on about just how much you'll be able to negotiate a commercial lease. But you don't have to sign the commercial lease. So make sure you read it. These things do vary significantly from place to place, what they count as what they'll call additional rent. The reason why they call it additional rent is because it's easy to evict somebody if they haven't paid their full rent. It's much more difficult to evict somebody for other reasons. So they call it rent, and then they come in and say, well, they haven't paid their rent, when really it's not, obviously, technically, it's not what most people would consider to be rent. It's what most people would be considered to be additional charges. I have seen certain leases where they will say our legal fees count as your rent. All right. So if, for example, they impose a tax, if the government imposes a tax on our business, on this building, and we fight it, win or lose, those legal fees are now your responsibility. Well, that's kind of interesting because the tax is their responsibility. So now you're busy paying their legal fees to try to fight back, maybe not the taxes, maybe the appraisal, whatever it is, whatever they invest in. You're now paying their legal fees, or a percentage of their legal fees, in order for them to fight something that has absolutely zero benefit to you. So I've seen contracts like this. It is something that's, like I said, it's worth looking at. I don't know that you'll be able to change it, but it certainly is. It varies significantly from lease to lease. And so it's extremely important that you review the lease and see what is included in this additional rent. And it'll be very clear. It'll be set forth. Additional rent includes the following things. So for here, we've got, taxes. That's fairly common. Insurance, that's fairly common. I think we're going to talk later on about common area maintenance. That's fairly common. One of the things you do want to make sure of with common area maintenance, though, is to be sure how much is your common area? What is your percentage? And there are different ways of handling what is a common area. How much of it is your percentage? If there's 10 stores, do you pay 1/10 of the common area? But let's say you've only got 5% of the square footage of the stores. Well, maybe you should only be paying 5% of the common area. So these are all different things to take a look at. Like I said, they vary widely by lease agreement. And it always surprises me, frankly, how much variability there is in the different leases from different entities and different building owners. So it does pay to shop around a little bit and see where you want to go. Okay, let's see. Can we go to the next screen? Perfect. All right, so here we have, like I said, this is an example of a basic rent. And this is, you'll see it, they'll break it up for you, much as in this chart. How much you're paying each year. This is obviously a 3-year lease, and how much you pay per square foot, or per square meter in this case, how much it is. And again, this is very, very similar to a residential lease, right? Where they say it's going to be, here's what you pay every year, and then we're going to divide it up by 12, so you make 12 equal installments of the monthly rent, of the annual rent. Okay, if we can go to the next slide. All right, now here's where things get very complicated. This is the additional rent that we were talking about, and it can mean everything. Here it includes late charges. This generally, by the way, in a lease agreement, which can run, I've seen them run up to 50, 60 pages. This can take up easily a page and a half of what is additional rent and how they're defining it. It's a little confusing in that frequently these leases are not written in English. I tell people it's legalese. It can be very, very complicated. But if you bring a paper and a pen, and if you've got the patience to really sit there and parse it all out, it will eventually become fairly clear. My experience with these contracts is that they're well written. They're not easy to read, but they will tell you exactly what they will tell you exactly what everybody's obligations are. They do set those forth pretty clearly. So the the landlords do not want to be in a position where they're litigating over what did this mean. They want to be in a position where they're kicking you out or evicting you or suing you for failure to pay rent, whatever it may be. And they don't want to be in a position where they're trying to decide, where the court is saying, well, I don't know exactly what you meant by this. Okay, so this is an example in English of the additional rent. And okay, let's go to the next slide where we talk a little bit about the use of the property. That says users, permitted and prohibited users. It should say permitted uses and prohibited uses. That will usually be fairly limited, and it's something to bear in mind because if you decide to change the scope of your business a little bit, you may find yourself afoul of the lease agreement. The owner of the building may decide that they don't want you there doing that kind of a thing. If you're selling tobacco and decide you want to start selling vaping products, they can tell you, no, you're not, that's not permitted. Usually the way these leases are drafted is they will say it's what we call inclusive. They say, this is what you can do. Anything that's not on this list, you cannot do. And so be very careful about exactly how broad or how narrowly that text is written. So that we can, and again, there's generally very little leeway. This is for negotiations. This is one of those positions where you might be able to have a little bit more leeway. If you say, look, I want to make sure I am able to do this, I sell telephones, but maybe in a couple months, 6, 7, 8 months, I decide I want to repair telephones, or maybe in addition to telephones, I want to sell computers or something along those lines. This will allow you to go ahead and do that. So make sure that you've got all of your possible uses in there. And then you can be as protected as possible. Okay. All right, let's go on to the next slide if we can. Okay, sublease. This is extremely important, and it's something that that we should consider. I'm looking on the side here. I see there may be a question. Do you want to ask it? Do you want to put it in the chat? Which way do you want to go?
Oh, yeah, David, they would like to talk. So if you don't mind pausing for a second there.
Please ask. Like I said, this is whatever questions you have. I far prefer it to if we can open a dialogue. That actually makes my life easier. So please, whatever questions you've got.
All right, I'm going to allow Woodall to ask the question.
But don't ask me hard questions.
All right, Woodall, go ahead.
Good morning.
Good morning.
Good morning. Thank you, first of all, for having this seminar. It actually came at a great time for me because I'm actually supposed to sign my LOI today, and I know you guys were going to get ready to talk more about the LOI before actually signing the lease. But one of the questions that I thought you was going to cover about the comment clause was right now in my LOI I'm looking at which I think is kind of fair, but I'm not for sure, so I want to know your opinion. The leaser want me to pay 50% of the utilities. And so what I told them at first, I wanted to see which utilities are you asking me to pay? That's number one. And number two, I want to see what is your current usage? What is your current usage that you guys are using before I agree to pay 50% of the utilities? And also, I wanted to make sure that they are not in the rear of with anything with their bills. So if they have, say for instance, they have a past due balance already of, let's say, $2,000, but you want me to come in as a new tenant and pay 50% of your utilities, then now that can fall directly on me because I agreed to pay 50% of the utilities. So when I reached out to Pepco and Washington Gas, they told me that I'm talking, when I reached out to Pepco for the electricity, they told me it will probably cost a couple of $1,000s to have an electrician to come out to do a separate meter, because that's what I originally wanted to do when they wanted me to come with the 50% for the utilities. When I reached out to the water company, they told me that everything is all on one bill. So I just wanted to know, am I'm in the right standing, which an agreement letting them know that, hey, before I sign anything, that I'm not responsible for what you guys got going on. If you guys are in the rear, I'm only going to pay the 50% of start my time when I sign my lease, the actual day where my rent is due.
Okay, excellent question. And again, I would go back to this. I don't know that the question is what's fair. I think the question is, what are you willing to pay? What are they willing to pay? It is not uncommon for the tenant to pay some or all of the utility bill. It's certainly not uncommon to have a sub meter like you were talking about. Sometimes they'll say, well, you're 25% of the building, you pay 25% of the utilities. I have a bit of an issue with that for similar reasons. What you were just saying is, well, I may be 25% of the square footage, but maybe the guy next to me is running an x-ray parlor and he's using 75% of the electricity, something along those lines, or he's constantly got his microwaves running or something like that. So I think a separate meter is probably not a bad idea. You may want to talk to the landlord about who's going to pay for the separate meter. I think looking at the previous bills is also a good idea. Something else you may want to consider is what kind of shape are these systems in? If the electricity is, I don't know how old the building is, if it's going to need major repairs. I had a client recently who was told, well, if the HVAC breaks during your tenancy, you're responsible for fixing it. And I said, that's probably crazy. But if you're going to do anything, make sure you have somebody look at it, make sure that you know that what kind of shape it's in. I mean, look, if it's an HVAC system that's a year old, it's probably not going to break in the next 3 years. But if it's 20 years old, you don't want to be the one left holding the bag because somebody else got 20 years of free HVAC service. So there's that. I think we wound up resolving that by saying that he would pay, or the landlord would pay to replace the HVAC as long as he paid to have somebody come in every year and check it and just do a general service check. So yeah, I think you're exactly right. Which utilities are you going to be paying for? Definitely take a look at the previous bills to see how much they're charging. If you're in a building that's got poor ventilation for some reason, or maybe great ventilation, and it's cold in the winter and hot in the summer, and you're paying, it could be a fortune. So that's all stuff to be considered. I agree with you. I think you're on the right track. Okay.
David, yeah, we have a few other questions in the Q&A, but do you want to wait until we go through it? I mean, I know, there's some specific ones, so
okay.
This one's kind of general, so
yeah, I see the one here. Let's hold off on this one until we get to the end. But I will happily get to it. But like I said, if there's a question about something specific that we're going over, feel free to raise your hand. Feel free to put something in the chat, the Q&A, whatever you want. Just somehow let me know that you've got a question about what I'm talking about at that moment, and I'll be happy to get to it at that moment.
Great. Yeah.
Okay.
So thank you.
Okay. Yes, and thank you for the question. All right, so subleasing. This is extremely important because when you're first starting a business, and I don't know where people are in terms of how long ago they started, how long they're interested, how much of a history they've got. But for people who are first starting their business, this is the golden era. This is the greatest time in the world. It's all exciting. Everything's just getting started. You've got all these great hopes for the future. And unfortunately, the fact is that most businesses, and I'm not trying to discourage anybody, I think small businesses are fantastic. I love small businesses. I love working with them. But unfortunately, most of them don't make it. The statistics are getting better. We've got services such as LEDC that help people when they need a loan just to get past tough times. So that's fantastic. And who help obviously work with them and help them be more successful. But even so, most businesses are going to fail. And so there should be some kind of a plan for what's going to happen if my business fails. Again, obviously your businesses are all going to be the ones that are successful. But for the other people, if anybody asks you about what we talked about today, it's good to know, it's good to have an exit strategy. So subleasing can be very, very dicey. There are generally conditions. They can be as severe as the landlord gets to decide whether it's going to accept a sublease, and it can do whatever it wants, right? That's essentially the same as not having any kind of a clause with respect to a sublease. If they can do whatever they want to. Now, I will tell you that most landlords will not agree to anything that's particularly liberal. They won't say, well, you pick somebody and we'll let them in. They are going to want to do a background check. They're going to want to do a financial check. They may want one or both of you to pay a large part of the first year's rent. What I usually put in there is when I'm reviewing a contract, I've never found a landlord who is willing to say, you don't need my consent. So what I do is I put in there something, when I'm drafting it, when I'm reviewing a contract for a tenant, it will always say which consent will not be unreasonably withheld, which is just a legalese way of saying, I think it's fairly clear. You got to be reasonable. You got to give me a shot at this. And the reason for that is now at least we've got something to go to a court with, right? If the landlord just says flat out, no, I'm not accepting anybody, you're on the hook, you signed a 3-year lease, you're doing it, then if we don't have that clause, then that's right. I mean, we're stuck with that 3-year lease. But if we have a clause that says, you can't be unreasonable, now the landlord has to be a little bit nervous about going to court and saying, Judge, we found somebody who was perfect. We found somebody who had great financial records. We found somebody who was willing to take on the lease. We found somebody who was willing to do everything that the landlord wanted, and the landlord just unreasonably said no. I have yet to see a lease that does not have charges associated with a sublease. Generally, that's going to be $1,500. They're going to charge you for their lawyers to take a look at it. They're going to charge you for to do the background check, to do the financial check, all of these other things. So the point, the takeaway from this is sublease is the option of being able to enter into a sublease. And I assume everybody knows what I mean when I say sublease. You just basically somebody comes in and takes your position in the lease. You want to make sure you've got the option to sublease out your property just in case things don't go the way you want them to. And you want to make sure that the landlord can't be unreasonable and just say, nah, I just don't like this person. I don't like the way he walked into my office. There has to be some reasonable reason for the landlord to say, no, we're not going to allow this person to come in and take over your lease. The landlord does have a duty under the law to mitigate its damages. So if you leave and you tell the landlord, and we'll talk about this more a little bit later, they've got the duty to say, well, we'll try to find somebody else to take your spot. However, if they've got 2 spaces that are identical, there's no reason why they have to lease yours first. So they can lease the other one and then say, you still owe us the money. So if you find a tenant, you should get the credit for that. It should come into it should go to your pocket, not necessarily to the landlord's. And again, expect some charges with that. Again, somewhere in the order of $1,500, something like that, just to cover their costs is what they're going to tell you. Okay, all right. I don't know why I'm not able to do this from slide to slide, but if we can go to the next slide, that would be great. Okay, every lease I've ever seen has something in there that will tell you when it is that the building is open. When it's open to customers. If you're in a mall, for example, the mall may be open. They may tell you that you have to be open from 9 to 9 or something like that. They may want to make sure that you stay open. So there's some policies where there is where there's a time where you have to be open, and you want to make sure, well, am I going to be able to cover that? I don't want to be able, they don't want bars in the middle of the workday. The mall doesn't. There's also the opposite situation, which is they may tell you can't work during certain hours. They may tell you for whatever reason, and maybe it's a fire hazard, maybe they're worried about security, whatever it may be. But they may tell you that, so you want to make sure that your business is going to fit well into the work hours of the building that you're going into. Obviously you don't want to be in a position where you want to be open from 8 to 10, and they're telling you can only be open from 9 to 9. You also don't want to be in a position where you only want to be open from noon until 11, 12. You've got a restaurant. You don't want to be in a position where they're telling you, well, the building gets locked at 10. Sorry. In addition to the hours, work hours or hours of access, those are hours for you to get in there. If you're in a restaurant business, for example, the fact that your restaurant is open from 9 to 9, you've got to get there. You may have to get there at 7:30 to start preparing, getting ready. So you want to make sure that your hours of access are available to you, that you're able to get in there when you need to get in there. Okay, it's fairly straightforward, but it is important. It is something to look for because it can get you into trouble. Okay, all right. Next slide, please. Okay, personal guarantees. This is a major issue, and it can be extremely problematic. If you find a landlord who is willing to rent to a small business without a personal guarantee from the owner, send them to me because they need legal counsel. There is not a landlord, there is not an experienced landlord out there who should be renting to a small business without some kind of a personal guarantee from the owner, and maybe even from more than the owner, maybe from the owner's family, maybe from all sorts of people. The reason why is fairly simple. If you own a corporation, an LLC, whatever it may be, generally that's what they call a limited liability entity, which means that they can't come after you personally if your business defaults on a loan. Well, if you've got a business and it goes under and it can't afford to pay its rent anymore, then there's nothing they can come after. The business has no assets. You can't get blood from a stone. So if the business has no assets, then they're going to want to be able to come after you. The best I've seen happen on a couple of occasions is limiting the amount of the personal guarantee. And again, what that means is that you become personally responsible if your business fails. If your business cannot make the lease payments, you become personally responsible. If you are married, they will almost certainly want your spouse to join on that personal guarantee. And the reason for that is somewhat esoteric, but the reason for that basically is if you're married, it's going to be very difficult for them to get to your personal assets unless your spouse also agrees. All right, we can talk later if anybody has some questions about why. We can talk later if we have time, but that's the long and the short of it. So again, be very careful with those personal guarantees. And that does work in conjunction with the sublease. If you can get somebody to sublease for you, then you may be off the hook for the personal guarantee. They may ask for personal guarantees from, like I said, other family members, partners, other members of your LLC. There's no limit to what they can ask for in a personal guarantee. And the question really boils down to everything, to almost everything else in contract law. Do you feel comfortable? Do you want to agree to that? Do you want to say, hey, if this business fails, they could come after my house. They could come after my wages for the next dozen years or more until this is paid off. I could be paying this off forever. So that's just something to consider when you look at that personal guarantee. And like the lease agreements, these things are generally drawn very tightly. There is not going to be much wiggle room to get out of it. They are going to come after it. And I do have some clients who were able to reduce their personal exposure. Sometimes it's as little as $30,000. Sometimes you can reduce your exposure to a period of time. So if you've got a 5-year lease, you can say, I'll personally guarantee the first 4. But if it goes out after the 4th one, that's, that's on the landlord. And some landlords will be willing to accept something like that. They'll figure, well, if the business can last for 4 years, then we'll give them a shot. We're willing to take the risk on the last year. So it is worth talking to them about. It is worth getting into with them. Expect to have some sort of a personal guarantee, and understand what that means is that you are now on the hook, and there is no way of getting off the hook, short of filing for bankruptcy or doing something else to protect your own personal assets. Okay, all right, if we can go to the next slide. Okay, and this is what we were just talking about, the almost impossible to avoid. With some landlords, it's possible to limit the liability, again, in terms of years or in terms of dollars, but generally you're going to be personally liable for some of it. All right, if we can do the next slide. All right, the responsibility of the landlords and tenants, like I was saying, everything depends on the lease. Everything depends on what you and the landlord agree to. You can agree that I'm going to lease this property from midnight to 6 a.m. And if they kick you out at 6 o'clock in the morning, well, that's what the lease says. Okay. There are some clauses that are either legally required or are so common that they're virtually legally required. They don't mean a whole lot. There is the warranty of habitability, which basically says, hey, look, what you think? You're going to keep this place above, freezing in the winter. You're going to keep it below 100 in the summer. You're going to make sure that I've got bathrooms, that my clients have bathrooms, my customers have bathrooms that they can use, things like that. But most things are habitable. I had a client recently where the toilets were backing up and there was raw sewage, and all right, that is not habitable. That is definitely a breach of the warranty of habitability. But again, it's difficult. If you come across a lease that tries to waive the warranty of habitability, that's easy. Go running. Don't come close to that lease. That's about the biggest red flag I can imagine. There is also the warranty, or and you'll see this in virtually every contract, lease contract. They are required to grant you what they call quiet enjoyment. Quiet enjoyment generally means that unless there's something somewhere else in the contract that says there can be very loud noises, oh, thank you. It's got to be very quiet. It doesn't have to be very quiet. It just can't be like 200 decibels. It also means that they are under some obligation to keep crimes at bay. They have to do some sort of security. If you've got, I had, to give you an example, I had a client some time ago. He had a very small building, and I think maybe 4 offices in the building complete. One of his tenants had an employee who really liked to smoke marijuana in the common areas. And eventually we put enough pressure on that tenant that he fired the employee, or I guess maybe the employee started working from home, I'm not sure which. And the reason was, and we got worried. We were a little worried that the other tenants would start to complain that this was a breach of the quiet enjoyment part of their contract. So, but beyond that, beyond not having crimes committed in the common areas, beyond some basic level of security, which doesn't mean that they are guarantors of your security, it just means that they have to have something, some basic ideas. If they know there's crimes, if they know there's stuff being committed, they've got to do something to try to stop it. And that's really the only obligation. So everything else, the responsibility of the landlord and the tenant, is going to be set forth in the contract. Again, these contracts generally run anywhere from 40 to 60 pages. So it's a lot of reading. It's a lot of single spaced. It's a lot of bringing a pen and paper and really getting into it. All right. So the next slide, we'll talk a little bit about the responsibilities of the tenant, which is pay the rent, like we were talking about earlier. Maintain the premises is also generally it's in every lease I've ever seen. what's involved in maintaining the premises. Generally, you're required to leave the premises in the same condition that you found it. They call it broom swept condition. That doesn't mean that excludes normal wear and tear if there's scratches in the paint, stuff like that. But you've got to do what's necessary to maintain the premises. Some of them, some leases I've seen actually require the tenant to maintain the outside of the premises if it's one of those strip malls. Like I said, I had a client who was required to maintain the HVAC. It's devil in the details. And just make sure you read everything that's in that contract and make sure you understand it before you sign it. Okay. All right. Next, we're going to talk a little bit about how to gain a little leverage in the negotiations. It is extremely difficult. It is, and the trouble is this: generally, the people you're talking to are either not the owners of the property, they're people who are property managers, or they are the owners of the property and they've got so many lawyers working for them. They've got this huge team of lawyers that neither of them is going to feel very comfortable changing the contract, changing the lease agreement. It's possible that you find somebody who's a little bit desperate. You may be able to take advantage. Generally, where you're most likely to get any kind of advantages are, one, they may offer you a few months free rent. That's easy for them to do, especially at the beginning. For example, I had a client recently. There was an entity. They didn't need the new space for another 6 months or so. But this entity, they had just finished renovating the building, and they had some sort of an agreement where they had to get a certain percentage of it rented. And so they gave my client, I think, a full year of free rent. They gave him the 6 months that he didn't really need it, and then another 6 months on top of it. That's easy for them to do. It doesn't require a whole lot of legal review. It's the space that they've got. So that worked out very well for them. The other thing that you may be able to negotiate with, that's the most common thing, is options to renew. If you do that, you want to make sure you know what the terms are. So if you've got a 3-year lease and you've got an option to renew for another 5 years after that, make sure it says in there that the rent will continue. There's every lease I've ever seen has an escalation clause. This year it'll be this much. Next year we'll add 3%. The following year 3%. So make sure that when you've got the extension, that continues at 3%. I've seen somewhere they say you've got the option to renew and we'll renegotiate the terms. Well, that's essentially nothing. I can always renegotiate the terms. Once my lease is up, I can always negotiate a new contract. You want something written that says you've got the option to renew, and we're going to give it to you at this rent under the same terms that you've got it under now. You may be able to get something in there that's perhaps a non-compete. This is an interesting event, and I'm not certain how it's going to play out. This is a new client of mine. He had a store in a mall, and he was the only one. Well, the mall decided to rent out space to 4 people who are in direct competition with him. And I was looking through his contract, and I didn't see anything that prohibits it. I'm now researching whether the good faith requirement, there may be a good faith requirement in there that prohibits the landlord from doing something like that. But I'd sure rather there had been something in the contract initially that said, hey, you're in this business. We're not going to allow anybody else in the same business to rent from us. If you own a pizza restaurant, you don't want another pizza restaurant right next door. So that's something to consider. And then the last thing about gaining the advantage or getting a little bit of leverage in negotiations is you have to be willing to walk away. You have to be willing to consider other leases. It's like anything else. If you fall in love with that car, you're going to pay $3,000 more than you need to. You need to understand that there are other places out there. And frankly, this is the most exciting part. This is where you get to make the decisions and you get to weigh, well, I'd really rather be in the mall, but they're charging me 200% more than these people who are, next door. Well, which is going to be financially better for me? Which of these decisions am I going to make? So it's exciting, but remember, if you're not willing to walk away, you're going to wind up paying. You may wind up paying a whole lot more than you need to for the lease or for a lease. Okay, what to do before signing a lease. I think this is probably fairly clear from what we've been talking about all along. Read the contract, read it very carefully, and make sure you understand all of the terms. There is the law of real property basically developed in the 1400s, and it hasn't changed a whole lot since then. And the law of leases is the same way. It does not make a lot of sense by today's standards. There's a lot of things that really, frankly, like I said, just don't make sense by today's standards. I remember back in law school, the professor came in and said, "Hey, who understood last night's reading?" And maybe 3 people raised their hands. He said, "That's great." He said, "For the rest of you, that's fantastic. What that means is you don't think like people from the 1400s. Unfortunately, you're going to have to if you're reviewing these things about property law." So understanding it may be difficult. It's probably not a bad idea to consult with an attorney, just to have somebody review it and tell you what each of the different provisions means. When I review a contract with a client, whatever it may be, but mostly it's leases, that's what we'll do is I'll say, all right, here's what this means. This should be a deal breaker. This should not be a deal breaker, and we just go through everything. All right. Re-examine the financial status of your business to make sure you feel comfortable taking on this new responsibility. That's just critical. You're at the beginning. For those of you who are at the beginning stages of a new business, it's a huge commitment. Opening up an office, opening up a space, opening up a space, it is just a tremendous commitment. Make sure you're ready to make it. It could be nothing ventured, nothing gained, but it could also wind up being a major problem for you down the road personally, which bleeds into the next one. Decide if you're willing to guarantee the lease. Like I said, I've yet to see a commercial landlord who is willing to lease to somebody without a personal guarantee, willing to lease to a small business without a personal guarantee. Make sure you're willing to guarantee it. Make sure your family members may have to guarantee it. Make sure everybody's on board, that they're behind you on this business. It is a monumental commitment. And you may want to see if there's other options. Can you work this business out of your house? Obviously, if you're cutting hair, or if you're a beauty salon or something like that, that's going to be real difficult to run out of your house. But if you're running a construction business, at this time, do you need a place to work out of, or can you go to your clients' sites to see their contracts, and can you do things like that? I do have a client who's a very successful general contractor. He doesn't have an office. He does all of his work out of his home. He's got a small office in his house, and he just goes from site to site, looking and talking to his clients. He doesn't meet with his clients at his office. He meets with them at theirs. That winds up saving him money, and I think they really appreciate the fact that he's willing to make the trip for them. Okay, next we can talk a little bit about what happens if problems that can come up after you sign a lease. All right, obviously the main problem is going to be if you can't comply with your obligations under the lease. First thing to do, get in touch with the landlord. A lot of landlords, especially nowadays, a lot of landlords are really willing to work with people. They're willing to reduce the rent. They're willing to take some rent and put it at the back end of the lease, meaning when the lease is done, we'll give you the last year. If it's a restaurant in a mall, for example, we'll give you the last year for free. We'll just extend your lease for another year. All right, and so they're willing to do things like that. So they may be able to work with you on that. At a bare minimum, your landlord should know that there are issues. Again, your landlord has the obligation to mitigate damages. The earlier your landlord knows that there may be a problem, the earlier the landlord's on notice, the earlier the landlord can really start to try to get things ready. If none of that works, get ready for litigation, because it's most likely coming. They're most likely going to try to sue on that guarantee. I can't tell you how many lawsuits I've been seeing, especially recently, where it's just the business and the owners and everybody's on the receiving end of a lawsuit. But there may be defenses. For example, this last client I was telling you about, where they allowed 4 different stores to compete directly with him to open up, that may be a violation of their obligation of good faith, which is read into every single contract in the state of Maryland. The other thing to be aware of, and this is extremely, extremely important, and I can't tell you how many clients I have who say, well, David, I'm not worried about it. They haven't gone to court yet. There's nothing they can really do until they get a judgment against me. That is absolutely true in a residential context. It is absolutely not true in a commercial context. If you failed to pay the rent, if you're even a month behind, the landlord is allowed to use what they call self-help. The landlord is allowed to come in, take your items out of your this place where you're renting, sell them, and use them to pay back the rent under 3 conditions. And the first condition is the contract has to call for it. Well, you can bet since that became the law in Maryland, every commercial lease ever has in there a clause that says if you don't pay your rent on time, we're allowed to come in and evict you. We're allowed to use self-help to evict you. So the contract has to have the clause that says that they can do it. Then you have to the tenant has to actually violate the agreement. And this is important. They have to be able to do it without violating the public peace. So, if there's people in the store, for example, they can't come in the middle of the day, start pushing people out of the store and saying, we're taking this stuff. But there's nothing to stop them from coming in at night and putting your stuff on the street or selling it to pay off whatever rent you're behind. So be very careful about that. It does come back. It can be a surprise, and it can be a big problem if you've got a lot of equipment, that's very valuable in your store, and pandemic hits, you're 3-4 months behind, and all of a sudden they're in there taking out this, a $10,000 oven that you invested in to make pizzas. It can be a real problem. So be ready about that. Make sure, and again, they can't violate the public peace. So make sure you're as protected as you can be. Make sure that you know that may be coming. All right. Next, we can talk a little bit about what can happen if the landlord can't comply. Same thing as before, get in touch with the landlord. That's always the first step, is get in touch with the landlord. It's possible the landlord will be able to fix the problem very easily. It's possible the landlord doesn't even know that there's a problem. I can tell you that my client who had the issue with the person smoking marijuana, that was in a whole separate county from where he lived and worked. He had no idea it was coming until somebody told him. So, it may be very simple. If it's a bigger problem, get ready for litigation. That means get all of your books in order, make sure that you've got all the records, make sure that you can prove that you've paid your rent every month. Make sure that you can prove that you've complied with all elements of the contract, because it's going to be awfully difficult to go against the landlord if you can't go in there and say, Judge, well, we didn't breach the contract. We did everything we were supposed to do. If the landlord can come in and say, Judge, they breached it first. They didn't do this or that or the other thing, so we were forced to do something, or we didn't have any more obligations. It gets very difficult. So make sure you're ready, again, for litigation. Unfortunately, it frequently will come to that. So that's about as far as I've got. Let me take a look at some of these questions. Okay. So let me go through some of the questions. The first question we've got
David, before we get going, so we have about half an hour. Thank you for that presentation. Sorry for interrupting you. At the end of this Q&A session, I will be administering a poll, and I didn't say this at the beginning of the webinar, but so we are, again, thank you to Montgomery County for allowing us to do this, but they are hosting a legal clinic, well, we're hosting it for them on July 13th. And this is open only to Montgomery County residents. But if you would like to be considered, we have limited spaces. Right now, we're trying to build capacity for it so we can serve more business owners in Montgomery County, and hopefully this is something that we can do for other regions as well if we show them that there's a need for it. So it's still important that you respond to the questions of the poll. But so after the Q&A, it'll be a short, about 9 questions. And again, if you're a Montgomery County resident and you want to participate in this legal clinic on July 13th, you do have to answer those questions. So and we'll go through a process of selecting the attendees. We'll be able to get in touch with you and ask you some questions and see if a legal consultation one-on-one will be something that will help with that. I mean, there's also other, through our Resilient Corridors program, we do have a budget for consulting services as well. So if your business is along the Purple Line corridor in Montgomery County and Prince George's County, you can also contact us for like a more in-depth consultation as well. So not just a legal clinic, but also, you become a client of LEDC, and then you work with a coach, and then the coach will also contact one of our attorneys as well to help your business with that challenge. And usually with the Purple Line businesses, it's a challenge directly related to construction. Well, now it's obviously COVID as well, so it's a double whammy for them. We also have services in the Wheaton area and Montgomery County countywide as well. I mean, the services there are more limited, are limited, but for sure, always get in touch with me. And again, for sure, answer those questions at the end of the Q&A so that you can be considered to attend the legal clinic on July 13th. And we will be scheduling others as well, so further in the year as well. So yeah, thank you so much. Thank you, David. And I'll let you, if you have access to the Q&A, I'll let you get through those if you want. And then there's also, I'm looking at the ones in the chat as well.
Yeah, right. Okay, so let me just echo what Javier just said. Please fill out that survey. Obviously, we all want LEDC to get as much funding as possible. It's a real quick survey. It's what'd you say, 9-10 questions, something like that?
Yeah, 9 questions.
It would be very, very helpful. So please just let us know. Even if you're not planning on coming to the legal clinic on July 13th, it would just be very helpful all around. So please do that. All right, so I'm going to get to the one in the chat first, because I know that I'll get to the Q&A one and then I will forget to come back to the chat. So the question here is, any advice for a short-term or a temporary lease for a pop-up restaurant? Yeah, I mean, first thing I would look at is how long is the term? And then the other thing I would look at is, again, coming back to the option to extend it. I don't know when I think of a short-term or a pop-up kind of an event, I think of something that's generally seasonally related, costume store around Halloween, Christmas store around, Christmas, something like that. But if you're thinking about a pop-up restaurant, if things are going well, you'd want to be able to keep that. So I would definitely be looking at an option to extend. I'd be making sure that that option would be on terms that you could agree to, that on terms that you could live with. As far as the rest of it is concerned, generally with those pop-up items, that's largely gravy for the landlord. So I would look for a pretty sweetheart deal in terms of common area, all sorts of stuff like that, because this is generally space that they can, if they can get a better deal in 2 or 3 months, they can go ahead and take it. So, I would be looking for a pretty sweetheart deal as far as the other things that we discussed are concerned. All right. What are the requirements to rent out your basement? All right. So the main thing is, and that's something that you'll want to look at, it's going to be largely county by county. Each county has its own separate law as far as landlord tenant is concerned. I can tell you, for example, in Montgomery County, there's all sorts of requirements about how long the lease has to be. Well, let me go back. I'm assuming, are you talking about renting it out for business, or are you talking about renting it out for residential use? So if you could respond to that either in the chat, and I'll get to the next question, which says, I have an initial leasing agreement 4 years ago. The original landlord sold the property. The new landlord didn't ask to sign a new leasing. Is that normal? Yeah, that actually is quite normal. Generally, and we didn't get into this because it doesn't come up often, but I'm glad you brought it up because it is an interesting question. Generally, commercial leases will say, hey, this deal that I've got is with whoever owns the building. And Mr. Landlord, if you choose to sell the building, that's up to you, but I'm here and I'm not going. So probably the new landlord probably the new landlord is, well, not probably, the new landlord is bound by the lease that you have. The new landlord may be thinking, well, I'm going to try to empty out this building. I'm going to let each of the leases die a natural death, and then I'm not going to renew it. I'm going to, kind of by attrition, and then I'll have the building. Or the new landlord may come to you in a few months and say, hey, look, it's time to renew. Do you want to re-up under the same terms? So that's, no, it doesn't strike me as at all unusual that the new landlord hasn't asked you to sign a new lease yet. I don't know how long the term of your initial lease was. I'm assuming it's 5 years. That's fairly standard. If that's the case, then you may get, you may hear from the landlord within the next 6 months, or like I said, the landlord may have other plans for the space you're in. There's certainly nothing wrong with you contacting the landlord, and this is something we didn't talk about, but check your lease to see what you need to do to renew. That's something we should have discussed with the options. What do you need to do to renew? A lot of times you need to give them a major heads up, 9 months maybe on a 5-year lease. Okay. Now, are these obligations the same if you have a commercial license instead of a commercial lease? I'm not really sure I understand the question. If you want to, let me tell you what I'm confused about. And if you want to re-ask it, I'll be happy to try to answer it. But generally, a commercial license, I'm thinking about a license to conduct business, whatever type of business you may have. So if you have a contractor's license, something like that, that's more with the state or the county giving you the right to practice your business. But the lease itself, that's with the landlord. So it's related, but it's slightly different. So I don't know that a license, they're not, I don't believe that they're interchangeable unless I'm misunderstanding the question.
Yeah, I'm allowing Natasha if you want to.
Oh,
unmuted her. So if you want to. Yep.
Hi there.
Natasha.
Hi, Natasha.
Can you hear me?
Perfectly.
Oh, perfect. So I have my landlord, basically I have what they call a commercial license. They don't call it a lease. And what I was told was that it's essentially a lease with less tenant rights. I don't know if that's actually true or not. But that's kind of the understanding that I had of this document, because it's essentially the same thing as a lease, but and I will say mine does not have a personal guarantee, so I guess I struck gold with that.
Yeah, don't tell anybody.
But yeah, so I ask that because I am running into issues with the property owners not maintaining the property well. And so that's kind of why I was wondering about the obligations. And I don't know. I don't know anything about legal documents, to be completely honest with you. So I wasn't sure if that's something or not.
Good. Generally, the less you know about the less you know about the law, the happier. People who don't know much about the law are generally happier than the other way around. But yeah, it's what do they say? Experience is what you get from reading a contract, and wisdom is what you get from not reading a contract. So, all right. So what I would tell you is this: whatever they call it, license, lease, whatever it may be, it's a contract. And DC is much the same as Maryland in that you can contract to do whatever you want to do as long as it doesn't violate the law or public policy. So take a look at the contract. I cannot believe under DC law, and I have not investigated this, that they don't have a warranty of habitability and that they don't have an implied warranty of habitability or the requirement for quiet enjoyment. I can't believe that no matter what they call it, they can get rid of those two requirements. Those are pretty deeply embedded in the law. So yeah, what I would do is take a long, hard look at the contract and see. But if it does seem like they are, that they're not maintaining the building properly, or that they're, that you think that it really does rise to the level of a breach of warranty of habitability, I would certainly take a look at it, whether they call it a license or a lease or anything else they want to. And I should say that I answered that question. I'm assuming everybody, and Javier, correct me if I'm wrong, everybody can hear the question, right? When somebody else speaks, if they're...
Yeah, they should be.
Okay. All right, good. when I'm in person, I like to repeat the question because somebody from the front of the room and somebody in the back room can't hear it. But okay. All right. So the next question, if one of the parties breaks the contract, how do you enforce the contract agreement? How much does it cost and how long can this process last? Okay, so it depends on which party breaks the contract. So if the landlord breaks the contract, the only real way to enforce it is by a lawsuit or if you can settle it before then, obviously. But the only real way to force the landlord to comply with the contract is through a lawsuit. How much it costs and how long it can take is just incredibly variable. If you can, and this is a little bit beyond what we were talking about, but I think we've got time, so I'm happy to get into it. There's two levels of trial courts in Maryland. There's one called the district court and one called the circuit court. The district court is cheaper and faster and easier. The circuit court deals with bigger issues. So if you can be in front of the district court, there's no jury. It can go by very fast. I usually tell people, 6-8 months from start to finish. If you're in the circuit court, I generally tell people it can go as long as a year and a half. What they call file to trial, from the date that you first file a lawsuit to the time you're done with the trial can be a year and a half. One advantage to circuit court is that it's more expensive for everybody. That includes the landlord. So people are more likely to try to settle if they can. But again, talk to the landlord first, if at all possible. Now, if the tenant breaches the contract, then the landlord's got a much quicker ways of going about things. In that sense, the law really is slanted in favor of the landlord. The landlord, like I said, they can use self-help as long as the contract calls for it. They can get an order of eviction. Generally, that doesn't take long. You're talking 2 weeks to get an order of eviction. So things move much quicker if you're the landlord than if you're the tenant. All right, so next question is, a business owner guaranteed a lease many years ago. Then there was, not surprising, then there was a pandemic. And now the business is a year behind on the rent. The first couple of steps to resolve the back rent with the landlord is call the landlord. There's one of the advantages of being able to contract to do whatever you want to is you can also renegotiate. If both parties want to do it, you can certainly come up with a new contract. You can change the old one. You can come up with a new one. I have seen a lot of the big players, the Wheaton Malls of the world. Some of the smaller building owners don't have this kind of flexibility, but some of the big players have the flexibility to say, look, we'll give you all last year for free. Maybe they're getting some kind of an advantage from the government. Maybe the government's helping to pay their expenses. And they say, we'll just put you on the back end. We'll just give you another year and, we'll do the same 3% annual increase, whatever it may be. So that's what I would suggest is first things first, get in touch with the landlord, see if you can resolve something. Always understand it. And again, this is also a little bit beyond the scope, but if you're the kind of person where they're not going to get any money from you anyway, for whatever reason, then you can negotiate that way also. I've got clients, some of my clients are wealthy owners that have had businesses in the past, and there's not much we can do. But some of my clients are just starting out, and this is all brand new. And sometimes I'll call the landlord and say, look, it's up to you. We'll give you $3,000 off a $25,000 loan, or we'll file for bankruptcy. My clients already knows the cost of a bankruptcy is $3,000. We'll give it to you, or we'll file the bankruptcy. And sometimes we can get people to negotiate there. Obviously, the goal is to not file for bankruptcy. I didn't really want to get into that, but just know that is an option, and it is something you can use, if nothing else, for negotiations. All right, so getting back to leasing out the basement, is it residential? Are we talking about, or business? I still don't.
David, let me unmute Michelle,
okay,
so she can clarify. She says,
oh, there it is. I'm sorry, you did say residential.
It's a 2-year NDC, 2-year lease.
Right. Okay. So again, that's going to be, as far as each individual jurisdiction, they do things very differently. I can tell you this, I would think long and hard before I rented out any real property in the district. It is extremely tenant oriented, especially residential speaking. There are all sorts of obligations that landowners have to their tenants. Yeah, I would be very, very circumspect about renting out any property in the district. I don't know how many of those laws apply to just renting out your basement as opposed to apartment buildings. But I do know that evicting somebody if they don't pay the rent is extremely difficult. Obviously, some people do make money at it, but you know, I've got several, not a lot. I've got a few clients who own property in DC and they can't wait to get out. So that's or they own apartment buildings and they cannot wait to get out. All right. But yeah, but again, as far as what the actual requirements are, again, warranty of habitability, making sure that these people, that there's actually a place for them to live, but do be very careful. DC landlord tenant law is extremely complicated. I've played with it tangentially and it is extremely complicated. All right, advice for the first location of a restaurant. What is the normal build out time? And what are some things? All right, so let's start with this. Normal build out time, that depends on, you know, if you're renting a place in the mall that's part of an eatery, obviously their build out time isn't going to be nearly as long as if you're renting a place that used to be something, you know, an electronics store, and now you're renting it out as a restaurant. That's going to take a whole lot longer. So I realize that's not much of a question, but it's extremely variable. Things to watch out for. There's nothing specific to restaurants. There are things, well, I shouldn't say that. There are things that are specific to restaurants that you'll probably know more about than I will, but I know that there are a lot of requirements as far as grease traps, who's going to handle all that. There's a lot of waste, let me put it that way. There's a lot of waste from restaurants, and make sure that the lease is very clear about who's responsible for getting rid of the waste. That can be, like I said, the grease traps. It can also be proper ventilation. There's all sorts of issues with respect to, you know, making sure that the food is safe, making sure that there's electricity can be extremely important if you're refrigerating food. The other thing I will say is if you're starting a restaurant, you're probably going to have employees. Be very careful about logging their time, making sure that that you know exactly when they get there, when they leave. There's all sorts of laws, at least in Maryland, and I believe in DC, that talk about if you fail to pay overtime, if you fail to time and a half, if you have somebody working more than 40 hours a week, there's all sorts of very, very punitive. So make sure if you've got people working at that restaurant with you, and I've seen this happen a number of times where the owner trusts people, especially if they come from the same country or they've got some kind of a bond. And then before you know it, there's a lawsuit for, you know, $50,000, $60,000, $70,000, and there's very few defenses to those. So, and what are some things that will give the property owners confidence in agreeing to a lease for a first-time restaurant? A personal guarantee is the only thing I can think of, especially if it's a first time. You know, if the restaurant doesn't have a major history, it's going to be very hard. How do you know if there is a personal guarantee? You'll have to sign it separately. If the business owner has an LLC, does that mean there is no personal guarantee? No, it's actually quite the opposite. If the business owner, if the business is an LLC, they're going to want the business owner to sign something, and it will be separate from the lease. It may be attached as as you know, an attachment, or it may be at the very end of the lease, but it will have to be signed by everybody who is going to be bound by it. And it will say at the top, guarantee, in big letters. They'll want to make it very clear that you knew you were signing a guarantee. They don't want to have anybody come back and say, well, I had no idea. It wouldn't be much of a defense anyway, but yeah, bottom line is, even after a cursory glance, if you signed a guarantee, you'll know you signed a guarantee.
David, I'm gonna, you can still answer the questions as we, I'm gonna set up the poll right now. I know we have
Okay.
You know, about 9 minutes left. So folks, if you can answer, and then David can also just keep answering questions as you complete the poll. So
okay.
I'm gonna get that started. All right.
Okay.
And so
right.
There you go. Y'all can see the poll, I hope.
Yep. Please, please, please respond. All
Yep,
right.
it's about 9 questions. There's some, satisfaction, but also, again, if you want to be considered to participate in the legal clinic of July 13th and you're a Montgomery County resident, then this is a requirement. And again, there's other services, in Montgomery County and Prince George's County related to legal consultation and legal advice, as well as some of our other markets as well, like in DC. But this is available through Montgomery County, thanks to, through a grant from Montgomery County. Yeah, so David,
Okay.
Mansour had a question about walking
Yes.
away from a lease.
Okay. So let me just say, anybody who gives me a bad review on this, I'm hunting you down. And so we're clear as a lawyer, that was a joke. I just want to make. All right. So is there an option to walk away from a restaurant lease due to the COVID crisis and not be penalized? The answer is maybe, but probably not. So every contract I've ever seen has something called a force majeure clause. It's lawyers used to look at it all the time. And frankly, about 60% of us didn't even know how to pronounce it. Basically, you may hear it referred to as an act of God clause, something like that, where it says it's just impossible to complete this contract because of an act of God, because of something else. Did the COVID pandemic qualify? My guess is no. It's going to, I haven't seen much case law on it yet, but my guess is that what we're going to find out is that the COVID crisis does not qualify as a force majeure, and that the tenants are still bound by their lease contracts. Is it possible leverage for in negotiations? If you can get if you can try to get some stuff at the back end of it, sure. No landlord wants to go to litigation any more than anything else. So than anybody else. So yeah, it's definitely worthwhile bringing it up. But I don't think that if you actually get to a court, I don't think it's gonna fly. All right. There's a question here, and I'm not ignoring it, but the fact is, I don't know the answers. Question is, what are estoppels? And ESSOPELS. I don't know the answer. It may mean, I don't know whether that's estoppel, which is something similar, which is something that's related to the law. Basically what it says is there are certain situations in which you're prohibited from doing something because somebody else has acted in reliance on your promise, for example. So you can't say, well, this contract had to be in writing. It wasn't in writing, therefore it's unenforceable. If the other person says, well, but I bought all this stuff and I did all these other things in reliance on this contract, then you may be what they call estopped from arguing that there's no writing. All right. And I think I saw one more question in the chat. So let me get to that. All right,
sorry, David, I did see someone pointed this out. So question 7, I know it's a little, because it says, what did you not like about the presentation? And you have to choose one of the answers. So if you did not like this presentation, you can say all of the above. And that's what I meant. So all of the above could mean you did not like any of the topics. So yeah, sorry about that. That's
okay. Yeah.
I said I with this poll. But I think that, there were a couple questions in the chat. I think you got to all of them. Did you talk about the pop-up?
Yeah, so we talked about the pop-up briefly. There's a couple more here. Is there any reason that the landlord has to have knowledge of the cost of the build out or revenue during the term of the lease? No, there really isn't, unless the landlord's responsible for the build out. The landlord may want to know. Generally, I don't know that there's any reason. The revenue, I have seen some leases where the where the rental payments are based on revenue. And so there, obviously, the landlord does have some kind of a say as to at least want to know what the revenue is so that they can figure out what the lease is. Generally, I have seen a couple of contracts where the landlord wants to know what the revenue is. I don't like to provide it just because I don't like to provide anything that I don't have to provide. But, sometimes my clients will say, well, I don't care if they know how much I'm making, whatever. That's, again, just up to each individual. Okay.
So I think Woodall has her hand up, so I'm gonna let her unmute again. I think,
Okay.
and I know there are a couple folks like I think Salamawit. I hope I'm pronouncing your name right. I think you had something in chat, but you didn't type anything. But if you want to, there's still a couple minutes left. So Woodall, I'm gonna unmute you.
So my question is, and this is my last question, and my question is about my building is pretty older building, and I'm going to be in DC, God willing, and so because I'm in DC, I'm trying to they require me to get a building permit because I'm going to change the use the use of the space, and so my question is, do you think that the landlord is it the landlord's responsibility to provide me with drawings if I cannot find drawings from DCRA or from the DCRA archives, or is it my responsibility to provide an architect to come out to submit new drawings if I can't find those drawings online?
All right, so it's two different issues. One is, can you find the drawings? Are you asking, does the landlord need to provide the drawings of the building as it exists? Or does the landlord need to provide buildings as to how you want it to be?
As it exists?
Oh, I would certainly, again, whatever's in the contract, but I would put in the contract that the landlord's required to provide those documents. You're finding them is going to wind up costing time and money. And if the landlord has them, and the landlord should have them easily available, there's just no reason. It would just be wasted time and money. I would certainly put something, if you haven't already signed the agreement, I would put something in the contract that requires the landlord to provide that. Yeah, absolutely.
So what if he can't, what if they can't find it? Then what should be the next suggestion?
If the landlord can't find the drawings as to how the building is right now.
Yes, because I think the building was made back in maybe in like the 1800s. So
all right. Yeah, that may be possible. Then certainly it's possible to get somebody in to make them now, to go through it now. That's going to be expensive. And it's going to mostly go to the landlord. It's going to be to the landlord's advantage. I would think long and hard about having the landlord pay for that. I think double check me on this, talk to maybe an architect or somebody to see what it would cost to have those the drawings redone. But if I'm right, that's certainly not an expense I would want to take on. I would want, especially since, like I said, the landlord's going to have it now. And for the next tenant, the landlord's going to be saying, oh, here you go, here are the drawings. I'd want the landlord to pay a big chunk of that.
Okay, thank you.
Yeah.
Thanks, Will. So we have, we're almost at time. So I'm putting David's contact here on the screen. We shared this. And I know Salam, which has, I'm sorry, someone has, here's some reverb. Anyways, but yeah, his contact is here. I put it in the chat. You'll also receive a copy of this presentation. I think we have about 17 answers to the poll. I appreciate it.
Can I ask a question? So I was raising my hand for a long time.
Yeah, no, we're not. We'll give you a little bit of time. I know that we keep this open because session starts at 11:30. We'll give it a few more minutes, but the next session will be in Spanish. So I'm going to just say it really quick in Spanish. Estamos aquí. Gracias por unirse a este seminario virtual con el Centro Latino para el Desarrollo Económico. La sesión en español empezará en unos minutos. Estamos terminando la sesión en inglés. Gracias por su tiempo. Esperemos como hasta las 11:33 para empezar la sesión en español. Ok, gracias.
Thank you to everybody who attended. You've got my contact information. If you want to get in touch with me, that direct dial number is a cell phone. So if you want to text to it, feel free. If you want to send me an email, feel free. If for some reason I don't respond to an email or a phone call, shoot me a text. That's probably the most consistent way to get in touch with me.
Okay, we're gonna go. Salamat, go ahead.
Okay. All right. So my name is Salamat. I'm the owner of Sugar Spin Cafe and Palaces Lounge. I have an issue with the landlord since we rented this place, you know, just as like I said, we have it in the court, but this is based on our lease. We are following the lease, but the landlord is like putting a lot of issues, you know, you know, for example, it's our utility is included with the lease, but we used to pay him without reading it briefly for several for 2-3 years. But you know, unfortunately, you know, just our lawyer found out that we pay him over that we're supposed to, and then he just keep sending us a bill every time, every month is increased. So just the final utility bill was 2,000, but we asked him to see the bill that whole, you know, the building. That's why we are paying that much. So he just doesn't want to show that proof. But so we had an issue. So we stopped paying him, and then he just returned the money that we had. We paid him over, we paid him like 24,000, and then he returned the 10,000. But after that, we just, you know, we had the issue came. And then he started turning off the AC. Now we have been like 5 years on the lease. We still have like 10 more, but we have an issue with the AC. He just turned off the AC after 4 o'clock, and then we don't have AC on the Sundays. So we been in the court, you know, just because of the COVID, you know, just the court was closed. We have an issue. The lease, you know, it's not even included with the lease. So we just, for this kind of harassment, what is the Montgomery County helping for the tenants, you know, just when they're being harassed by the landlord? So you said he has the right to write on the lease, but if not on the lease, and then just if it's harassing the tenants by doing this, how we gonna be supported, or how we gonna get solved from the county? Just my question.
All right, so again, it's going to come back to what the lease says. If the lease says that that he's got to have the hours of operation like we were talking about, I don't know, you said it was a restaurant?
Yes, it is a restaurant. We gave him the operation of the hours. He knows that's the restaurant.
Okay.
When we signed the lease, it's going to be the restaurant. So the hours of the operation is like, you know, listed. But,
Okay.
you know, yeah.
It sounds like he's in breach of the lease. And I would certainly consider, if not, I would certainly consider getting in touch with him, seeing if you can resolve it. It sounds like you're not going to be able to, because it sounds like you've already tried this. And beyond that, I would very seriously consider bringing a lawsuit to enforce the lease, because you can't run a restaurant without air conditioning in the summer. I mean, that's crazy. Nobody who's going to want to, you know, I mean, some people will, but it's awful hard. It's good, you know. I would certainly think about bringing that, and there may be ways that you can get it to trial a little faster than a year and a half, because that's just going to be devastating to the business. So, you know, you may be able to get, and again, we're way outside the scope of what we're going to talk about, but there's something called an injunction. You may be able to enjoin him, which we, the court, saying, no, you got to leave the air conditioning on. You can't shut it off at 4 o'clock on Sunday. So that's a possibility. It's worth looking at, because I mean, like you're saying, and I agree with you, if he's shutting the air conditioning off at 4 o'clock on a Sunday, well, that's a restaurant's busy time. And in the summer, no air conditioning is pretty detrimental to a restaurant.
So yeah, thank you, Salama. If you, you know, you can always email us. You have my email here if you want to follow up. And again, I hope you responded to the questions in the survey. But we're going to get started in the Spanish language session. So thank you everybody who stuck around with us. Thank you, David. You know, here's our contact information. can always find us on our website as well. And you know, if you do like this and you do want to support us more, you know, follow us on Facebook and leave a comment. And you can also volunteer to work with us or donate through the link. And you will all be receiving a PDF of the presentation. So, all right. Well, thank you so much.